Hello, this is Jim Blackburn, and this is the second hour of a 3-hour program. The beginning title is Starting Over Today, and the mental health portion is entitled Hiding in Plain Sight. It gives you 3 hours of continuing legal education for lawyers and also for paralegals, because any program that is approved for lawyers or attorneys is automatically approved by the bar for paralegals. Now, in order to make this interactive, I need to ask a couple of questions throughout the program. You won't really know when those questions come or the answers, so you really have to watch the whole thing to get the questions and answers. And of course, that's the whole point, to make sure that the bar knows that you have actually seen and watched this video. If you need to ask me a question at any time, you can stop the video. You can call me at 919-326-9070, 326-9070, or my cell phone, which is the same area code, 919-889-7316, 889-7316. Or you can send me an email at jim@blackburnseminars.com, jim@blackburnseminars.com. And I would suggest that after you have had a chance to see these videos, that's perhaps the simplest and easiest way to contact me, just to let me know you've seen it. Therefore, I can send you a certificate if you're a paralegal, or if you're an attorney, I can turn your name and bar number into the state bar so that you get full credit. As we were talking about in the first hour, I think at the beginning and at the end, there were several basic principles, and I want to just briefly summarize what those are as a way of starting back in again, that I think are critical and essential to understanding what it would be like for an attorney or a paralegal to start over today. And I based that title on the precept that no matter what you have done up until this point, today is a new day. You can start over and try to do it all differently or better, or improve upon what you did yesterday or last week or last year. There's nothing that prevents you from doing that, no matter how long or how short a time you have practiced law or been a paralegal. You can just start all over again. It's really up to you. In order to do this, I really don't name the specific rules of professional conduct in these programs. Rather, I talk about different principles that are embodied in the rules of professional conduct. And I would just say to you that, I don't know, I think that I do this in terms of telling stories. And so this is a sort of a relaxing hour, I hope, that you can just sit back and watch and enjoy and listen to what I talk about. Before beginning with the second hour, I want to briefly summarize these principles that we talked about in the first hour. They were building and keeping trust with clients, communicating with them often and honestly, giving clients individual and complete attention, keeping all communications with clients confidential, not over-promising on what is possible, never guaranteeing a result, and following through on whatever appropriate promises you have made. Avoid even the appearance of impropriety, and never ever take money from your trust account for any reason at all. Do not overbill your clients. Represent your clients with passion and to the best of your ability every single time you represent one. And that the truth is the most important asset you and your clients have, and so you should use it. I really wish, if I were 25 or 26 years old, which is what I was when I started first being a lawyer, I could start out with some of the understandings that I gained during the last several years of my life in the most difficult year, that of 1993. I remember sometime in the fall of that year being in a law office in downtown Raleigh with my two attorneys, Wade Smith and Rick Gammon. I don't remember what time of day it was or what day of the week it was. I just remember it was sometime in the fall of 1993. That was a tough time for me. I had been indicted by the Wake County Grand Jury. My case was going to be placed on the calendar soon. It wasn't yet on the calendar, but I knew that was coming. And I knew that I was facing an uncertain future. I would go for lots of long walks up and down Ridge Road, which was not far from where I lived at the time. And I would sort of think in my own mind about planning my future. What I would like to do. Would I like to write books? Would I like to speak? What would I like to do? How can I start over? And yet, I could not really make any firm decisions about starting over, because I did not know what the future was going to bring. Wade Smith and Rick Gammon had told me the previous summer in July that I faced a significant amount of time, perhaps being locked away. I didn't know how to proceed with that. I didn't know, for example, if I started something now, if I would be able to finish it. And so I wanted some certainty. I wanted to know what might happen. I wasn't really ready to just roll the dice. I wanted to know. And so I wanted to go easier for me. I wanted things not to be quite so tough. I didn't want to make a statement about how proud or strong I was. I just wanted it to be over. That's really what I wanted. And I had a friend who was with the State Bureau of Investigation. We had been friends for many years. We worked on cases together in the past. And he would talk to me sometimes over the phone or at lunch and give me some suggestions as to what he thought I might do to make things go easier for me going forward. It seemed reasonable to me. It doesn't seem unreasonable to me now, quite frankly. So I went to my lawyer's office that day and sat down and talked with them about this, what he had said to me. Their reaction was not really good. I was surprised. I thought they might jump on it and go with it. But that wasn't what their reaction was. One of my lawyers, Wade Smith, who had been sitting behind his desk, and I was a chair, in front of his desk, he got up, walked around, the side of his desk, came up, and he really got in my face. And he hit me. Not hard, not a slap, but just sort of punched me. He's a big guy. He used to play football at Carolina. That startled me. Nobody had ever done that to me before. I asked him why he did that. And he looked at me and he said, "Jim, you have got to get past this. You have got to get over this. There is only one way back for you in your life. And that is, you have to take their best shot. You have to take it. You need to own it. You need to be able to go in front of the judge and say, Your Honor, I am here. I'm responsible. I did these things. I'm ready to be punished. You don't need a plea bargain agreement. You don't need to compromise. You don't need to wheel and deal. The district attorney does not want to give you a deal, Jim, because you're prominent and it would make him look like he might be playing favorites. We don't want you to take a deal. We want you to stand strong. You know, as I sit here in this chair looking at this camera and to you, I can say these words relatively easily because I know what happened as a result of all of this. When these words were being said to me, I did not know. And I remember saying back to Wade, if I should do this, do you think anyone will ever know? And he said to me, Jim, if you do this, you will have more riches than you ever dreamed possible. This is the way for you to get your life back. It is the only way to get your life back. I would like to tell you, well, I jumped up and clapped my hands and hugged him and shook hands all around and said, yes, let's go do that. I agree absolutely. Let's go do that. That's not what I said. I said, let me think about it, or words to that effect. And it took me weeks to think about it, frankly. I spoke to friends. I spoke to Dr. Halleck, who was a psychiatrist appointed by the court. I'm sure I spoke to Dr. Spaulding about it. I do remember talking to a couple of paralegal friends of mine. One of them was still with the law firm I'd been with, and she thought I was crazy. She thought I was certifiably crazy if I did that. And there were those who thought that way. This was not a slam dunk. As it turned out, cutting to the chase, that's what I did. There was no plea bargain agreement. You know, when they give you a transcript of plea, it's a one-page thing that you have to sign. It's front and back. It's somewhere near the bottom of the first page or the top of the second page. I don't recall which. It has a blank about filling in the terms of the plea bargain agreement, if there is one. And in the space where mine was, it had N/A for not applicable. This was a roll of the dice. Now let me be honest, I did not think the court would give me all the years that the court could give me, running them consecutively in active sentence. I did not think that. I was still hoping, for probation. But I knew that it was open-ended, that the court could do pretty much whatever the court wished, and I could not challenge it. That's as vulnerable as I ever want to be in my life. I tell you this story slowly and in some detail because it is perhaps the most significant conversation I ever had with my attorneys. It turned out to be, I think, in retrospect, the correct thing to do. I got a sentence of 3 years that was active, but because this was before structured sentencing, I was only sentenced to a term of essentially what turned out to be 3 1/2 months. And because a month equaled a year in terms of parole, they don't have that law anymore. It was changed the year after 1994 in a special session of the General Assembly. But that was the law under which I was sentenced at the time. The reason I want to speak about this is because the lesson I learned then, that I wish I had known when I was younger practicing law, and that I think all lawyers and all paralegals should reflect on today, is that the greatest power you have when you mess up is to own your mistakes. What do I mean by owning your mistakes? I mean, you need to say, I am responsible. I made a mistake. No one else is responsible. It is up to me. No excuses. No whining. Even if you think you're entitled to do a little of that, do not do it, because that's what will be remembered. What you want people to remember is that you took it. So if today you're working in the legal profession and you make a mistake, either intentionally, willfully, or inadvertently, by accident, and it is found out, or you come upon the mistake before anybody else even knows, I will tell you the smartest thing that you can possibly do is to say so, is to take responsibility. And that's the way out. If there's any one way out of a mess in which you've created, it is to take responsibility, own your mistakes, and say so. That is perhaps the smartest thing a client can hear from you as a lawyer or you as a paralegal. I made a mistake. I want you to know. I will try to do better to the extent that I can fix it honorably and ethically. I will do so immediately. Not tomorrow, but immediately. And you need to say, folks, you need to say these words, I am sorry. Don't say mistakes were made. Don't say if this offended you or upset you, I am sorry. Don't condition it. Just say so. That's the lesson I learned that I don't think you see enshrined necessarily in the rules of professional conduct. They perhaps are implied there, but not specifically stated. But based on my history and my own experiences, that's the smartest thing that I did. I wished I had done that sooner all through my legal career when, I made silly mistakes or forgot to call somebody back, or any small minor error. I wished I had done that. I wished every week, if not every day, I got to the end and said, have there been things I have done that were mistakes that I should have done differently? Could I have done that? That would stand me in good stead with my clients, with my law firm, with the bar, with simply everyone. And so I would say to you, that's so important. I think one of the things that I remember most from Judge Dupree when he was trying cases, we would often have bench conferences and jury trials. And, you'd go up to the bench so he could talk to you and the jury wouldn't hear, and you didn't have to send the jury out of the courtroom, which would take additional time. So he'd call everybody up to the bench, and the lawyers would would stand there next to him. And in federal court, unlike state court, they transcribe bench conferences. I don't know why they don't do it in state court, but they do in federal court. And Judge Cipriani oftentimes said when he was trying to make a difficult ruling on some evidentiary issue, he would look to both lawyers from both sides and he would say, I want to treat everybody equally. It's not my case. It's not really your case. It's the public's case. And I want to treat everybody equally. And he was fond of saying, I want to feed everybody out of the same spoon. I heard that lots of times. Oftentimes, frankly, that meant I was getting ready to lose some request that I made. He was going to rule for the other side, I guess. But today, I think that's so important for law firms, for attorneys, for paralegals, for anyone to treat everybody equally, treating them out of the same spoon. You know, I learned that not really in the practice of law so much. I really learned that when, believe it or not, when I was waiting tables for tips at 42nd Street Oyster Bar in Raleigh. And I used to want to make $100 each night. They called it back then a bill. Sometimes I would make more, sometimes I would make less, depending on how much people ordered, how many people there were, how large the bill was, whether they drank wine, had dessert, appetizers, that sort of thing, would increase the chances that I'd have a better tip. So obviously, to wait on 3 or 4 people at a table trumps waiting on 1 or 2 because the bill is larger and you make more money. That's the way it's worked. But yet, it's so random how you're seated. It depends on who walks in the door and who's gotten the last table, and is it your turn to get another table? It's like, you know, Russian roulette, or that's sort of like spinning a wheel. It's like the Wheel of Fortune. Where does it end up? It can go from 1, or it can go to 4, or it can go to 3. If you've got a big section, it might go to 6. But you're not going to get, unless it's very unusual, all 3 tables with 4 people at each table, so you've got a total of 12 to wait on. That's not going to happen at one time. It's more than likely going to be 4, 2, maybe 3, or even a 1, particularly at lunchtime. But lots of 2s, lots of 2s. And I learned then, and learned early, that I could never guess who was going to leave me the biggest tip. That wasn't possible. I had no idea, no clue. I could only do the very best with each table as though that was the most important table in the world. And I learned to do that. And I learned timing. I learned that if I made some mistakes, which I surely did, mistakes like ordering in something incorrectly, or forgetting to order something in, or forgetting to bring an appetizer because I forgot to order because I wrote it down too quickly. You know, I had to say so. Now, I could minimize those waiting mistakes by checking back on a regular basis with the table to see if they had everything they needed. And then might tell me, well, what about our appetizer, or that drink, or something like that, and I could go and get in real quickly. So it does help to stay in touch with your clients, to talk with them regularly, to see how they're doing, to take their pulse, to see what else you need to be doing for them. I know this is an open-ended question to ask somebody, but I will tell you, it's so good to say, is there anything else you need for me to do? Do you have any other questions? I did that a lot when I waited tables. And you know, I was not, never would be, never will be the most polished waiter you have ever seen. I'm just not. But I could, for the hour or so that you were in the restaurant, make you have a good experience to the extent that it was within my control. I could bring you your food on time. I could take your orders. I could get your bill to you so you could pay and get on with your life and business of what you're going to do the rest of the evening if it were at nighttime. And I could do it with a smile on my face. And I could interact with you. Didn't matter who you were. It did not matter. And I enjoyed it. I wished I had made more money than I did, but I have to tell you, I look back at that time and think back and have to say to you that I enjoyed it. I learned then the wisdom of treating everybody the same. As Judge Dupree said, feeding everyone out of the same spoon. And so I want to say to you, when you represent clients, you need to treat them the same, whether they are a bank or a one person walking in off the street who's paid you some money and asked you to represent them, and you have agreed to do so. Once you have agreed to do so, you owe that client the best effort you can give. And if you will do that, then tonight you can put your head on your pillow and you can go to sleep knowing that you have done your best. That's the key to the whole thing. Of course, in the practice of law, you're not going to be able to finish a case in one day. Of course, a client is going to be ongoing. It's not like waiting tables where you come in and you're one and done, that kind of thing. It's a long process. But each day is separate. And each day you can do the best that you can. You can speak to the client. You can try hard. You can talk to them. You can call them on the phone. You can send them an email. You can respond to their questions. And if you do so, even if they email you 5 times or more, if you make every effort to do so, at nighttime when you cut off your computer, turn off the light and leave your office and go home, or if you take your work at home, you close the light off at the night and go to bed, you will know that you have done your best. And if you have done that, you're absolutely not going to have a problem. Or if you do have a problem, it is not going to be one of your own making. I would say to you that one of the most important aspects of training that a young lawyer or any paralegal can learn is the requirement or the necessity to treat everybody the same, to feed everyone out of the same spoon. That is the greatest legacy, to my mind, that Judge Dupree has left. He passed away in the mid-1990s, but is to say that he treated everyone who appeared before him the same, regardless of who you were, how powerful you were, your station in life, all treated the same. Now, Judge Dupree wanted you to be prepared. Woe be unto you if you walked into his court unprepared. You didn't do that. So it is true with your clients. When they come to see you, be prepared for them. You know, one of the things that I wished I had done also, I may have done this on occasion, but not like I really should have. I wished I had said more often, you know, how do I want this picture show to end? What is it I want to accomplish with this client? Do I want to get them off? Do I want to get it compromised? Do I want to settle it? What is it that I want? And think up some way or roadmap to get there. I want to know in advance, to the best that I can, what it is I want to accomplish, how I want this to end up. That's really what I want to know. And that's what I think I should focus on. I can only do that if I am somewhat prepared to talk with the clients when they walk into my office the first time. I want to have some understanding of why they're coming to see me. I want to offer them some hope. I want to give them some understanding that I will be with them until the last dog dies, so to speak. That's what they want to hear. That's surely what I wanted to hear when I was a client. Owning your mistakes. Treating everybody equally. Feeding everybody out of the same spoon. I put down one of the rules of professional conduct implied here, that you should avoid even the appearance of impropriety. What on earth do I mean by that? That's one of those general phrases that can mean anything. No one listening or watching this video is going to say, well, yeah, I want to appear improper. Of course you don't. Nobody does. But are there some steps, some specific steps that you can take, that you can do, that will help you avoid even the appearance of impropriety? I think that there are. I'm going to run through them and then come back to them, and we'll talk about each one. I used to say that I wanted to do something that I wouldn't be embarrassed if it appeared on the front page of the Raleigh News and Observer. And if I was embarrassed, then I shouldn't do it. That's a heck of a good rule of thumb. I wish, I had followed it. Ask yourself this question, okay? If at the end of today, I had to explain to my law firm or my spouse or significant other or my friends or family or the newspaper or the bar or the court or whoever, the public, what I had done and why I had done it, would I be bothered by anything I did? How open and transparent am I really prepared to be? Am I really prepared to be an open book? That does not mean, folks, that you go out and put up a billboard or put up a video on YouTube or anything like that and say, this is what I did today. I'm not saying that. But what I am saying is to act in such a way or conduct your business in such a way that you would be okay doing that. Could you do that? Could you today, at whatever time your workday ends, say, everything I did, I would not mind telling anyone why I did those things. Keep in mind the rules of confidentiality, of course, that you have to have with clients. But could you be ashamed of anything you have done? If the client wanted to challenge you, could the client challenge you? Have you said something to the client that was puffed up? Perhaps not quite accurate. Have you promised something you don't think you can really do? Have you made statements against someone you should not have made? When you said you had done some legal research and drafted a complaint or an answer or pleadings or responses or anything like that, have you done so? Or have you started? Do you have a rough draft? Where are you? Have you talked to the district attorney, or have you just intended to talk to the district attorney? Did you talk to someone, or did you just leave a voicemail? And what is it that you tell a client? How many little black white lies do you say? What I am saying to you is, one of the ways to avoid even the appearance of impropriety is give yourself this rule of thumb. I don't mind if the newspaper prints tomorrow all that I did, keeping everything in confidence that would have to be there. One of the most awful things that I have to admit is this. I was a partner in the law firm, and we had a young lawyer who had graduated from the University of Virginia. Nice guy, proper guy. I thought he was a little bit too straight-laced. I thought he was a little bit too anal. I thought he was obsessed with small stuff. Do you know he would keep notes of minutes. Keep notes of meetings in which he would participate with me. He'd come into my office, sit down, and he'd take notes. That's a good idea. But he also told me he would go back to his office and dictate those notes. I don't know that we had even computers then. We may have just been getting computers. But somehow we would get notes transcribed to a file and keep them. And I remember asking why he did that. Doesn't that take a lot of time? He said, well, yeah, but I want to have a record of everything that I'm doing. I thought to myself, how silly is that? And I have now concluded that he was the one who was right and I was the one who was not right. I don't know that you have to take notes of meetings every time you meet with somebody. But do you, when you have major conferences with a client, when it's over with, is there any record of what took place? I have to say to you, I bet you when I practiced law, I didn't do that very much. I just had the meeting, talked to them. Probably they didn't take notes either. Some took notes, some didn't. Some even wanted to take recording, which always made me suspicious. I was very skeptical of that. But that's okay. I shouldn't be saying anything I don't want somebody to know. Keeping in mind confidentiality. And so, I think if I were you, and a client came to see me today, and I met with that client, when the client was through, it was over with, I think I might write the client an email, which remember has a stamp of today's date and time, and perhaps summarize briefly what took place in the meeting and what my expectations are for the client, what the client's expectations are for me. I would stamp it attorney-client privilege, and I would put it in my file, and I would keep a permanent record as well as a record on my computer or even an external hard drive. I know this is very anal, but I would do it. And then I would rest knowing that I had done, all that I was supposed to do. If I had misstated something or misjudged something, or I had unreasonable expectations, or if I didn't put down something that I was supposed to do, or didn't summarize the meeting correctly, then the client could let me know. And you say, well, the client doesn't want to pay for me taking the time to do that. Then you have to make a decision, folks. Whether it's, for what reason are you doing it? Are you doing it only because you're going to get paid for it, and if you don't get paid for it, you're not going to do it? How dumb is that? You shouldn't have to be paid to protect yourself. Now, I admit and agree that if you're sending an email to a client asking the client to do something, of course that's an appropriate billing thing to do. But just to protect yourself, just to make notes of the meetings, put them in your own file to remind you of what to do and what has been done, that's a close line. I don't think it has to be in any great detail, but I would cover myself. I would protect myself, and I would do that. And if possible, send them to the client. What I hear most from lawyers that they hate most, even paralegals, everybody hates billable hours the most. If there's one cause for depression, perhaps in the practice of law, it's the billable hour requirement. It's that there's pressure to bill for everything that you do so that you're a profit center, whether you're a paralegal or a lawyer. Well, that would have been one of my great weaknesses. That would have been one of my great weaknesses as a lawyer, because I didn't like to do that. I didn't want to do that. how can I turn that weakness into a strength? I would learn to tweak my thinking about it, and to tweak, if I put down that I'd work 15 minutes or 30 minutes on a particular item, put it either on my computer or on a sheet of paper or something, however the law firm where I kept those records, I would think that this would indicate that my day was being productive. And one of the reasons I think, quite frankly, I did not like to do that, it was a very black and white demonstration of how unproductive some of my time was. If you think about it for a moment, why don't you take a requirement that you have and make it a plus? Why don't you make it an asset? Why don't you say, I'm looking forward to seeing how many hours tomorrow I can build with quality work. And so at the end of the day or at lunchtime, you know whether you're before or you're behind or ahead. Why don't you do that? Let me tell you a secret. Every waiter in the United States does that in a different way. You could have asked me at any time during a 5 or 6 hour session or work shift how much money I had made. If I knew I wanted to make $100, I knew at 7 o'clock if I'd made 15 or 45. I knew at the halfway part, if it was like from 5 to 11, I knew around 8 o'clock how much money I had made. I knew. Every waiter does. They know. And at 10 o'clock, I knew whether I needed to make $20 more or whether I was going to fall short. I knew how much money I'd made. I had to go get it confirmed with the bartender who, signed me out, collected the money, as she did in the back wait station each night. But I knew the same principle. It is perhaps present in keeping billable hours. It really is. You know by lunchtime whether you've worked 1 hour that you can bill, or if you've worked no hours that you can bill, or you've worked the whole morning and can bill it. And I know that working on a major matter where you can put down 2 hours is like working on a table where I can work on serving 4 people. And working on a matter that's only 15 minutes is like working on a customer who's only 1 person. And my goal, though, is to collect all of those at the end of the night and see how close I can get to that $100. And so the goal at the end of the day is to see how close I can get to that magic number of hours that I need to bill that day to keep current and consistent throughout the week. Take a liability, take a weakness that you have and that you absolutely dislike, and make it a game of strength. A game of strength. And by game, I mean to see how well you can do and compete, not against your partners or your clients, but to compete against yourself. What can you do to make your time productive? What can you do to not let time just go away? Is your practice an open book? Can your secretary and your paralegal come into your office and go through your desk or your files and find anything they should not find? Do you keep secrets in your desk? Are there some drawers that are private that you don't want anybody to see? And if so, are they personal or are they professional? If you go on vacation next week and you don't call the office for a week, you just check out. Let's say you just check out. They can contact you by leaving you a voicemail if something goes wrong. You can perhaps check your emails. You can check to see if anyone has called you. You can check to see if there are any emails to respond to. But try this. Try not contacting the office for a day. Just a day. Take it off. And then try it for more than one day. And then, for goodness sakes, try it for a week. Can you go a week without contacting your office and everything not fall apart? That's a good test. You know, there's a bank in North Carolina that has a requirement, more than one bank may, that they want their employees to go on vacation for a week. And if anything bad will happen, it will show up. And the rule is they can't contact the bank during the time they are gone. They can't do any bank business on the idea that if anything's bad or unfortunate, it will surface, during that time. That is a way of avoiding impropriety. What is one of the most important things you can do, folks? You can own your mistakes. That's the first question. What is one of the most important things you can do to maintain a good law practice? And that is to own your mistakes. How should you treat clients? The answer is you should treat them equally. You should feed them out of the same spoon. There'll be one more question before I'm through, but those are two questions. If you have bad news to tell clients, do you tell them? I had a hard time with that. I really did. I always wanted to tell people happy news, make them feel good. I wanted to see them smile and say thank you. So I would promise them sometimes things were going to be better and we were making progress and we should feel good about this. And they would feel good. That makes it really hard to tell them it's not going as well as I thought. We're not going to win. We're not going to do well. Tell your clients bad news if you need to do so. Realistically, with some kindness, with some understanding, with some patience, and try to help them through it. Try to look at alternatives to see what you can do, what you can accomplish. I think, frankly, this avoiding the appearance of impropriety, this general rule, this general principle, has subsets. And I think the way to avoid that is to be as close as you can to being totally open and totally transparent. Be as close as you can to being an open book as is possible. That is what I think you should try your best to do. Wouldn't that be wonderful to be able to do just that? And so, as we go forward in the last few minutes here of this particular hour, I want to talk about some remaining concepts. I used to say that passion was the most important characteristic trait that I thought any attorney or paralegal could have. And it is very important. It's not, however, perhaps the most honest, the most important ones are clearly integrity, honesty, truthfulness. Passion may not be a trait, though. It may not be a character trait. That's where I may have made a mistake in the past, calling it that. I rather think that passion is something that you find from time to time. I think you find passion when you find your niche, when you find something that you enjoy doing, when you find that you're in a cause that's bigger than just yourself. You're not painted by the numbers. And I would just urge you, as hard as I can, to try to find that first within the scope of what you do as a lawyer, as a paralegal, as an attorney. Try to find that. If you like a certain kind of practice of law, go to that. And the reason that I say that passion is important, to find your niche. It's so important to find what you do well and to do that. Every one of us has one or two traits or characteristics or talents that are unique to us. Perhaps you are a great trial lawyer. Perhaps you love patent law. Perhaps you are great at real estate. You're great at numbers. Perhaps you are, a great criminal mind. Use those in the way, the practice of law that fit you. Don't try to be a duck out of water. Don't try to be a block in a square in a round hole. Don't do that. It will make you uncomfortable. It will make you not very good. I learned that what I wanted to do most and what I miss most from practicing law is the courtroom. Not an appellate courtroom, though that's okay, but a trial courtroom. It's fun to me. It's fun now to me to go make presentations in conferences or seminars. That's partly why I enjoy doing them. It's more fun than most anything else that I can do. I learned that I like doing that. So if you find that there's something that you're good at and that you enjoy doing and that you like to do, go for that. It's not too late, no matter how old you are. It's not too early, no matter how young you are, to try. But if you try something and it doesn't work, don't close up shop and think that you are a failure. Just try something else. It would be, I think, about 7 years, maybe 6, as a lawyer that I had before I ever tried my first case in front of a jury. And I was scared to death. I did not know which table to sit at. I did not know how to make objections. I did not know how to, ask jurors questions that were appropriate or meaningful or important. I never did quite get over that because that was always hard for me, asking jury questions, because I thought it was very stilted and formal and tough. But I loved having witnesses on the witness stand. I loved cross-examining witnesses. I liked making opening statements. I liked making closing arguments. I want to tell you a story that's sort of a humbling story. The Jeffrey MacDonald murder case, which was tried in 1979 now, quite a long time ago, decades ago. The legend of that trial was that if Wade Smith had been given all the time to make a closing argument rather than just a few minutes that he had, their side might have won. The equal legend was that we won, in fact, because our closing arguments were really very good. Indeed, not a few minutes after the jury verdict, an FBI agent saw me outside the federal courthouse and said that he had heard on the radio that one reason they had voted for us was because of the strength of our closing arguments. So for so many years, I thought that was the most important thing in the world. Well, I have to tell you, several years ago I was having lunch in Raleigh with one of the former jurors, and I asked him about this. And he sat across the table from me, he laughed and said, "Jim, I hate to tell you this, but neither one of those theories that you have about closing arguments by either you or Wade is true. I don't even remember your closing argument." So I said, "Well, why did we win?" He said, "Jim, you won because the facts of the case were on your side. And you all presented them clearly to the jury. That's it." That's not very dramatic, is it? It's not a slam, bam, thank you, ma'am sort of approach. But it tells you something. The way to get the best result for your clients is, first of all, do they have good facts on their side? If they do, you still have to present them in a meaningful way. You have to present those facts in terms of a story the jury can understand and relate to. If the facts are not on your side, then it's not so easy to do, but you can minimize those facts and play to your strengths. I'm reminded so much about a story of professionalism. Not mine, but I have to tell you this prelude to the story on professionalism I want to mention. Judge Dupree had given each side 3 hours and 15 minutes to make closing arguments to the jury, which is a long time. It was a day of court which he'd given us 6.5 hours. And the government, the prosecution went first, and we went in the morning. And by lunchtime, we were done. We were through. But we had reserved 30 or 40 minutes for rebuttal because we had the right by statute to refute or rebut anything the defense said. And they went after lunch. They had the 3 hours and 15 minutes. And there was this big clock, round clock, on the wall above the jury box. And so the lawyer who is arguing to the jury can see what time it is. And the defense had reserved an hour for Mr. Smith to make his closing argument at the end, and Bernie Siegel to go first. But Bernie got carried away, perhaps with the sound of his own voice and the arguments, that he was making. And he took, folks, almost all of the time. He encroached into Wade's hour. The truth is, he took all but 60 seconds of his 3 hours and 15 minutes, leaving Wade 60 seconds to make a 1 hour closing argument. I was afraid that Judge Dupree, might give the other side some additional time and give us additional time as well. And I didn't want that because we had prepared and organized our time as to how it was going to work. And so I offered Wade at the break 10 minutes of my time. The judge would allow that, which he did, and the court and the jury knew that I had done so. During those 10 minutes, Wade was able to get the jury very quiet and listen to what he was saying. It made me nervous. I was glad when he was through. And I got up and made about 20-25 more minutes of rebuttal closing arguments. And then it was over. This was in 1979. In 1981, in the spring, I am prosecuting a federal criminal case against Wade and Roger Smith. It's an environmental law case with the Environmental Protection Agency, where a person had orchestrated the dumping of PCB chemicals on the roadsides in northeastern North Carolina. And we were prosecuting the person who owned this PCB and arranged for it to be disposed of. And we were picking the jury for the jury trial. And under the rules at that time, each side got 6 jury challenges. And as we were selecting the jury, I realized that we had 11 jurors that we had passed on, but I had already used all 6 of my jury challenges. And so I got a little bit alarmed, not too alarmed, but a little bit alarmed. So I remember looking back over my shoulder into the courtroom where the other potential jurors were sitting, and everybody looked okay or normal, whatever that means, so I relaxed. I would just pass, on whoever came up, unless there was a major reason for cause. And this young man got into the jury box, and Judge Earl Britt, who was the presiding judge, started to ask him questions. And he started to give answers. And almost as a throwaway question, he asked the juror, do you know any of the parties here today? Do you know anyone in the courtroom? And the potential juror hesitated for a moment, and he finally said, well, yes, he did. And the answer was, well, who do you know? And it turned out that he knew the defendant, and that he knew him well, that they had been friends. He had even been to his house on at least one social occasion. But the potential juror said he did not know anything about the case, and he promised that he could be fair and impartial. So I motioned to the judge that I would like to approach the bench, and went up to the bench and said to the judge, Your Honor, I would like to respectfully request that you take this juror off for cause, because he knows the defendant is a good friend of him. They've been to his house on a social occasion. And Judge Brett looked at me and looked at his sheet of paper there on his legal pad and said, well, Jim, I understand why you'd want to take him off, but I can't do that. Because he's answered the questions honestly. He didn't have to tell me he knew the defendant. He said he could be fair and impartial, so I'm going to leave him on. And then, of course, he put his hand over his mic and said, Blackman, you're screwed. You've not paid attention. You may lose this case. And Wade Smith leaned across the podium there at the bench and said, Your Honor, I've been wanting to do this for almost 2 years now, since the McDonald trial. And Jim gave me 10 minutes of his time. I want to somehow repay that favor. And so he says, what do you mean? He says, well, I'd like to offer him, if the judge will allow it, one of my jury challenges that he can use to take this juror off. And the judge said, well, I think that's highly irregular, but I will allow you to do that. And so he did, and I took the juror off, and we won the case. I tell that story a lot. Almost every lawyer I tell it to thinks that this was perhaps not a good thing for Wade to have done. That was not the zealous representation of his client. Judge Brett, on the other hand, regarded it as the most professional thing he'd ever seen done, and recommended Wade for an award to the Fourth Circuit Court of Appeals in Richmond for professionalism. He tells that story even now, I think, or he did a few years ago, that that's the highest form of professionalism he'd ever seen in the entire time he'd been on the bench. And lots of times when young lawyers are being sworn into federal court in courtroom, he would tell that story. Now, I tell it to you today not to suggest that that's what you should do at all, but to suggest that what I have heard over the last 10 years that I've been doing these seminars across this state and other states is that so many people say the practice of law is not what it once was. That we have somehow lost the feeling of professionalism. And it's dog eat dog today. And take any opportunity you can to beat the other side. I asked Wade one time, 2 or 3 years ago, why he did that for me. And he responded he wasn't trying to be just sweet or nice, but that he was trying to send a signal to the court that he was a serious lawyer, that this was going to be a lengthy trial. There were going to be significant motions and objections and arguments to the court, and he wanted the judge to know that he was serious. He wasn't just going to be flailing about. And he thought this one might go to the benefit of his client. And in his view, this was the zealous representation of his client. Being professional in whatever way you choose to be professional, it doesn't have to be this way, but being professional as a lawyer or as a paralegal does not require and is not inconsistent with the zealous practice of law. Indeed, I think you can argue easily that being professional is in fact the zealous practice of law. I'm really on behalf of your client. Practice kindness in the courtroom. Practice kindness over the phone. Practice kindness with your clients. It will come back to help you in so many ways. I want to ask you as the last question, what is one of the most important things you can do to be a member of the court of the legal profession? And that is to practice kindness towards everyone. Plato has said, as I've repeated before, that be kind to everyone you meet, because everyone is fighting a great battle. The clerk of court, the potential juror, even the judge, a bailiff, a witness. You don't know what people are going on in their lives when they come into the courtroom that day. And practice kindness towards them. It will work to your benefit. It will work to your client's benefit. I hope you have enjoyed this second hour of ethics and professionalism starting over today, and I hope you will use every opportunity to start over today.